Today we're going to take a look at searches. After we have a crime occurring, there's usually an investigation. And in that investigation, there may be a search. That is very common for the police to search or the government to search. And there are some rules when it comes to searches. The Fourth Amendment of the Constitution protects us from unreasonable searches and seizures. So we need to look at what does that mean. Well, first of all, we need to understand the term reasonable expectation of privacy. And it's self-explanatory. It is where a person can expect, where is it reasonable to expect privacy? Now, think of it like, where do I expect that no one's going to be looking through, that I can be private here? Well, your home, certainly, your car, your backpack, your phone, your person, your purses, your blood, your phone conversations, your text messages. We have a reasonable expectation of privacy in all those places and more. Okay, so the rule is that if you have a reasonable expectation of privacy, the government can't search it unless they have probable cause. Now, if they have probable cause, then it is considered a reasonable search. So probable cause is a good reason to believe that a crime has been committed or there's evidence to be found. It doesn't mean that you're absolutely sure that you're going to find evidence, but it's also more than a hunch. Another way of saying it is, it's something that is articulable, that you can explain why you searched it. So let's say that a police officer pulled you over for speeding. And as you're pulled over for speeding, they walk up to your car. That's not probable cause to search your vehicle. They can give you a speeding ticket, but there's no reason to search your vehicle. Okay? So they don't have a good reason to believe. But what if they walk up to your car and they smell the distinct smell of marijuana coming from the car? That is a good reason to believe a crime was committed. It's more than a hunch. But they're also not absolutely sure. You might not have marijuana in the car. Maybe the marijuana is on your clothes. The smell is coming from your clothes. They're not absolutely sure there's marijuana in the car, but it's more than just a hunch. Okay? It's articulable. Why did you search the car? I smelled the odor of marijuana coming from the car. They can express, explain, or justify the search. Now, our rule is that you need probable cause to search, or the government or the police need probable cause to search. And the more intrusive a search is, the more probable cause it is typically required, meaning a strip search is more intrusive than a pat-down search. So they need more probable cause to conduct a strip search than maybe a pat-down search. But probable cause is a standard that we have to understand. Now, there's another standard called reasonable suspicion. And reasonable suspicion is less than probable cause. It's more than nothing. Meaning if you're driving down the street, that's nothing. But it's less than probable cause. It's not enough to search. Now, there'll be some exceptions to this, but we have to get this down first. It is enough to investigate further and to hold somebody for a limited amount of time. Okay? So let's say that someone is pulled over for speeding, and they talk to them, and the person sounds as if they slurred their first sentence. Well, the police officer doesn't know if they're drunk, doesn't know if they can search their blood for alcohol within the blood, or even search the vehicle for alcohol in the vehicle. But they want to investigate more. So they ask the person to get out of the car. They watch them walk, see if they're stumbling. They talk to them a little bit longer, see if they're still slurring their words, or if it was just, nervousness or whatever. Either way, they're investigating further. And if that person then, let's say, is stumbling or fails a sobriety check, a sobriety test, or slurring their words, that may be probable cause to search. At first, all they had was reasonable suspicion. It gave them the right to investigate further, to try to determine if there's enough probable cause to search. But it's not enough to search in itself. Sometimes police officers need a warrant. They always need a warrant to search a home. But they don't need a warrant to search everywhere. Now, what a warrant is a legal paper issued by the court giving police permission to either search a place or to arrest somebody. An arrest would be a seizure of an individual. So sometimes police need an arrest warrant to go in the house and get people. In order to get a warrant, police must present probable cause to a judge. And they're under oath. They present that probable cause to a judge. The judge determines if there's enough probable cause to issue a warrant. If there is, the judge issues a warrant, which is permission to go search. So if I have probable cause, if I'm a police officer and I have probable cause to search your home, I present that probable cause to the judge. The judge issues a warrant, but the warrants are fairly specific. The warrants must include the what they can search for and the where they can search. So if there's probable cause to believe that you're selling drugs out of a house, the warrant may include looking for drugs or scales or money or anything that could be used in the sale of drugs. Where can you search? Well, where is there probable cause to believe you search it? That it would be found. So let's say the house itself. Well, that doesn't give you permission to search the outbuilding. Or let's say you're searching for a stolen TV. Let's say there's probable cause to believe there's a stolen TV. And you get a search warrant for that. Well, where can you search? Well, anywhere where that TV could be. That TV could be in different rooms, maybe in a closet, but that TV couldn't be in like a file cabinet or a desk drawer or something like that. It wouldn't be in your diary. So they can't search everywhere in the house. They can't read through your books or your diary or look through your contents of your computer if they're looking for, in this case, a TV. They can only search where that item could actually be found. So what if they extend the search? What if a search is conducted without a warrant when a warrant is required? Or what if a search is a probable cause-less search? Essentially, then, that search is illegal. Now, there's something called the exclusionary rule that says that any evidence that was obtained through an illegal search cannot be used against the defendant in court. So that evidence can't be used against you. If the police illegally search your car, let's say you're pulled over for speeding, they have no probable cause to search your vehicle, they search your vehicle and they find something illegal within that vehicle, a stolen item or something. That could not be used against you in court because they did not have the right to search to begin with. That's called the exclusionary rule. It is a suppression hearing, is when your lawyer would try to get that evidence dismissed from the case. And the judge would have to determine if that evidence is usable or if it was obtained illegally, then that evidence should be suppressed. That's the exclusionary rule. Now, there's also something known as a fruit of the poisonous tree. It's not the same as the exclusionary rule, but it's similar. The fruit of the poisonous tree is essentially saying that once the primary evidence is determined to have been illegally obtained, any secondary evidence is not allowed either. Meaning that, let's say that we illegally search your car. Okay, and let's say we find within your car evidence that you're selling drugs from your home. Okay, well, that evidence that you're selling drugs from your home, I guess, would be probable cause to search your home. But because the search of the car was illegal, you can't use anything to search your home either that was obtained through that illegal search. It's also used sometimes with coerced confession, but we'll talk about that on another day. That's the fruit of the poisonous tree. An arrest warrant is simply just a warrant to arrest somebody. It's not the same as a search warrant, but it's assigned by the judge. It's permission to enter someone's home to arrest them. In order for police to enter a home, the general rule is they need a warrant. If they want to enter a home to arrest somebody, they need an arrest warrant. If they want to enter a home in order to search somebody, they need a search warrant. Now, that's a real quick overview of some of this material. Now, we'll look at the exceptions to the search rule here in the next video that I create.